Good morning. I'm Father X, talking about how fathers can win their child custody case. In this episode, we're going to talk about your first day in family court and the lessons I learned that can help you. Let's get to it. Why does this matter? The first day in family court is extremely important because temporary custody orders made on that day usually last a long time. If you walk away from that first day in court as a non-custodial weekend parent, it makes your challenge so much greater to get 50-50 or primary custody. In this episode, I'll discuss lessons I learned so you don't make the same mistakes I did. I'll give you arguments you can use for the judge that I wish I had known. At the end of this video, I'll also give you 6 legal clauses for you to have the judge add to any custody orders made on this day to protect your parental rights and enable co-parenting. Let's separate actions you can take before court gets involved and things you say on that first day of court. Before court gets involved, if the mother is assaulting you, do you have her arrested? If you call the police, you might get officers who assume the woman must be the victim. But if the officer understands you're the victim, you can have her arrested. You have to decide, do I want her arrested, knowing this might be the end of the relationship? And if it's the end, then we might have a custody battle in a courtroom that's biased in favor of mothers. Also, if she's the kind of person that'll physically assault you, then she might also lie to the police to have you falsely arrested. If she has you falsely arrested first, then she can use that as leverage in court and during child custody and support negotiations. So maybe you have her arrested first. It's hard to know the best option because the court and police may or may not be gender biased. So plan ahead instead of reacting. Many lawyers advise you to be the parent that goes to family court first. But as a father, the last thing you want is a custody dispute inside a courtroom that's biased against dads. If you go first, you might be walking into the lion's den. But if the mother is assaulting you and she's arrested, then maybe you go to court first because she could be at a disadvantage. And that's what many mothers do to fathers. If you hear the sentence that whoever files first usually gets primary custody, think about whether that privilege is only reserved for mothers. So if you're going to break up, it's better to first mediate a settlement where you each have 50-50 custody, instead of going to court at all. If you hire a lawyer before going to that first day in court, spend at least a couple of hours talking about how the goal is for you to get 50-50 or primary custody on that first day. Strategize with him on exactly what you'll be presenting. Do not let him fly by the seat of his pants. If your lawyer tells you that the court may be biased against dads, tell your lawyer that his goal is to counteract the judge's prejudice. Tell your lawyer that if he can't get you equal parenting on day one, he might lose you as a client. If you don't have a lawyer, then do this goal setting and strategizing yourself, maybe with a friend who is also a parent. Create 2 to 3 parenting schedules that gives you 50-50 custody, where your child sleeps in your home 50% of the nights. And I don't mean that you see your kids for a 2-hour dinner on 50% of the days. Be sure to write out the proposed schedules that you'll give to both the mother and judge on that first day. I have sample schedules in episode 2A. I'll go into more detail when I discuss mediation in future episodes. Be sure that your 50-50 schedule splits summer vacation, spring break, Christmas break, and major holidays. If your job prevents you from being a 50-50 parent because of time limitations, think hard about which one you want to lose, your job or your children. For me, losing my son was far worse. Immediately think about hiring babysitters, especially grandparents, or changing your work schedule, or creating a custody arrangement that aligns with your work schedule. For example, if your kids get out of school at 3 p.m., but you work until 6 p.m., don't give up 50-50 or primary custody. Instead, find a babysitter for that 3-hour time slot so you can parent from 6 p.m. until you put your kids to bed. Single working mothers have to make it work. So can you. If you have a flexible work schedule, make sure the court knows your work revolves around your kids' schedule. Here are some tips and arguments for your first appearance in court. My arguments target 50-50 custody, but if your facts justify you getting primary custody on day one, then adjust my arguments accordingly. You must be assertive but not aggressive during that first day in court. I discussed this in episodes 4A and 4B. Assertive means you're pushing forward your case and your facts and not allowing everybody in the room to ignore you. One mistake men make is to show up and expect wisdom or fairness to happen. If you sit there quietly as if whatever happens, happens, then assume whatever will happen will only be terrible for you. Don't be passive. Force an intelligent conversation about the best interests of your kids, which includes you as an equal part of their life. My mistake was that I assumed the court read my petitions before our appearance. In hindsight, that's a terrible assumption you should never make yourself. You have to write your claims clearly in your petitions, but assume the judge didn't read it. So you also have to verbally state the facts out loud in court, and also state the conclusions the judge should make from those facts. Before I continue, please like, subscribe, and share. Also, if you find this information helpful and you want to support this channel so I can make more videos, please donate via my YouTube channel's About page. You can donate via PayPal or Venmo. On your first day of court, the goal is to figure out where your children should live until you have a full trial. But ask the judge to confirm this first hearing is only to decide temporary custody, and confirm that a final order of custody will be made after a full fact-finding trial. Don't focus on how much you and your wife hate each other. Instead, show that you can communicate and coordinate with her as co-parents after your divorce. Show up ready to discuss the facts and real solutions about where your children should live. Assume the judge is the most ignorant person in the room because they don't know the real facts of your situation. If you leave it to the judge to do the thinking, then you're likely to get the status quo where default custody goes to the mother. I'll give you sample speeches you can make to your judge using the court's language. Tailor these to fit your specific circumstance because I don't know the facts of your case or your judge. You can say, "We're here to decide the best interests of our children and not the best interests of the mother or father. I understand you've never met me or the mother before, seen us with our children, nor have you lived in our home. And the same goes for the lawyers here. I'm petitioning the court for primary residential custody of our children. However, I recognize you don't know the facts of this case, and we haven't had a trial. So I'd be asking you to be unfair and prejudicial to give me custody at the start of these proceedings, just like it would be prejudicial to give the mother temporary custody today. Her rights are equal to mine. Therefore, I'm asking the court to make a temporary order for 50-50 custody with this parenting schedule, dividing holidays and summer vacations. However, by the end of trial, I intend to prove that I can better meet the needs of our child because of X, Y, and Z." And you state some reasons. Also, be sure to address issues that may prevent 50-50, such as parents that live too far apart. And if the mother breastfeeds, she can pump and freeze breast milk and give it to you for your parenting time. So take that silly excuse away from everybody. You can also tell the judge, if each parent starts with 50-50 custody today, then there's a greater likelihood we can mediate on equal footing and make decisions in the best interests of our child together. However, if you give the mother primary custody today, that will anchor her into that position and make it difficult for us to achieve settlement out of court. Be aware, dads. You and your ex-wife might start mediation to settle this out of court. If the judge gives primary custody to the mother on day one, then she'll have significant leverage over you during mediation, and it may be impossible to come up with a fair mediated settlement. The mother can tell you that the judge has already given her custody, and she doesn't have to give you 50-50. And she can blackmail you by asking for a lot more child support for you to get equal parenting time. You have to block the court from enabling this outcome. After these general arguments, get into more specifics. You might have 10 or 30 minutes to speak. It's hard to predict, so be flexible. Tell the judge Your job is to raise your child, and you cannot execute that job if you're forced to be a weekend or alternate weekend parent. Tell the judge you're prepared to be a single dad who can take care of your child in your home without the mother, and that you can co-parent with her overall to coordinate parenting. Talk about your deep involvement in your kid's life. If your kid is an infant, talk about how you feed him, change diapers, and soothe him when he cries. Talk about how you care for him at night. It would be detrimental to your child's bond with you if you disappear from the majority of their life and become just a weekend parent. If your child goes to school, talk about how you make breakfast or take them to school in the morning. Talk about how you pick them up after school and do homework with them. Talk about how you read to them and put them to bed in the evening. Give details about your involvement with your children, their friends, their social life, and their extracurricular activities. Talk about the mentoring you provide your child. Discuss how eliminating you from their daily life would be detrimental to your child psychologically. You're divorcing the mother, not your child. It would be impossible to justify to your kids why daddy disappears except for weekends. And if your child truly prefers to be with you, tell the court. Don't be petty by complaining about the mother's minor faults. It only makes you look spiteful. If she has good parenting traits, say that, and say you can co-parent with her. If you're going to say negative things, focus on the mother's specific behaviors that show it would be either dangerous or detrimental to your child if the child mostly lives with her. State specific facts and not general concepts. If she's violent, share details about the mother's anger or violence, including police reports. Detail how she verbally or physically assaulted you in front of your child, and that this is detrimental to any child's well-being. Detail her anger management problems or physical abuse that was directed at your child. If a child is exposed to frequent anger from a parent, it has a negative long-term psychological effect on the child's self-esteem and confidence, even if it's the mother. Google it and see. Your job is to force intelligent thought regarding the best interests of your child. Don't assume the judge can think intelligently. If the mother abuses alcohol or drugs, and it impacts her ability to care for your child, then bring this up. If the mother has undiagnosed or untreated mental health issues, discuss how this can impact the child's emotional development. If the mother has blocked you from seeing your kids for no legitimate reason, document it and show the court she's not fostering a relationship with the other parent, and you need 50-50 custody to ensure your role in raising your child. If the mother is making false allegations against you or is making false statements, don't let her or her lawyer get away with that. Quickly jump in and say, there's what the mother says and then there's reality. The mother said A, B, C, but in reality, X, Y, Z is true. Say it as a matter of fact, without anger. If the mother lies in court, then the judge might assume it's true because you didn't bother to contradict her. Always immediately point out when the mother or her lawyer are lying in court. Say something like, it's not in the best interest of our child to have his future determined based on the lying of the mother and her lawyer. We need to make decisions based on reality and not fraud. And you have to be a truth teller yourself. You need to ensure the mother is the only one lying and that the judge can't look at both of you as liars. Otherwise, you lose your competitive advantage. If your child has always lived with a mother and not you, that situation requires a different strategy. The court is likely to not force a child to immediately stay overnight with a stranger, even if it's the father. It's just a slower process. You'll likely start off visiting your child to create a relationship, then try to quickly move to overnight visits at your home, and then in the custody trial, prove with the best interest factors from my episode 5A that you're a better parent for your child and that you should have 50-50 or primary custody. Also, if you haven't lived with your child, but the mother is an immediate danger to the child, that changes everything, and maybe you have the kid stay with you right away. On my first day, the court gave custody to the mother only because she was unemployed, and I had a job, so the mother was available to raise our son, and the court ignored all of the other best interest factors. If I could do it over again, I would have quit my job on the spot and taken that excuse away from the court. For your personal notes, go into court with a list of the best interest factors I provided you in episode 5A. The judge might pick 1 or 2 reasons to rationalize why the mother should have primary custody. So then discuss the other factors that justify why you should have 50-50 or primary custody. Whatever excuse the judge uses to rubber stamp the mother, neutralize it immediately to take away that excuse, and then say, okay, now let's have 50-50 custody. For example, the judge might argue that if before your divorce the father worked and the mother was a stay-at-home mom, then everything should stay the same and the mother should have primary custody while the father works. Your counter-argument will be common sense. Before the divorce, there were 2 of you dividing 2 responsibilities in one home. Now that you're divorced, each parent has 2 responsibilities. It only makes sense to have 50-50 custody where each parent is a parent for half of the child's life, and each parent has to work to support their own new household. You can't replicate the old division of responsibility in 2 new households. It's illogical. In hindsight, I wish I would have known how terrible the child support orders are. As the non-custodial parent, depending on your state, child support can be around 17% of your gross pay for just one child. That's gross pay, not your net take-home pay. You may not have enough money left over to live. And then you have this enormous support obligation that makes it hard for you to pay the cost of family court, like lawyers, forensic evaluators, and court transcripts. Paying child support handcuffs your ability to pursue a trial to figure out the best interests of the child. This is a massive weakness in the family court process, especially since child support awards can often exceed the actual cost of raising a child. When paying child support, many fathers can't afford a custody trial, and then they have to settle out of court and remain the non-custodial parent. So then we totally skip the process where somebody determines the actual best interest of the child, and the mom gets custody. Child support orders can drive you into poverty, so don't agree to be the non-custodial parent if you can avoid it. I've told you to be polite in court. However, there are times when lawyers and litigants yell at the judge, and depending on how it's done, it can be okay. So if you feel the judge is biased against you for no legitimate reason, and you sense they're going to rubber stamp the mother for custody, and you're seconds away from being railroaded, you might want to argue the following. We're here to determine parenting time in the best interest of our child, based on the totality of the circumstances. Based on everything that's been presented, I don't see how this custody arrangement is in the best interest of our child. I can certainly see how it's in the best interest of the mother, but that's not how the law says we're supposed to decide this. This isn't a case where the mother gets default primary custody and everybody's supposed to pretend that it's also best for the child. So can you state on the record the totality of the circumstance that leads you to a conclusion that primary custody should go to the mother? When the judge fails to provide a thorough reason, then say, the law gives us equal rights, so we should have 50-50 custody until there's a thorough analysis done at a fact-finding trial to minimize one parent's time. If the judge tries to wiggle out of this, then you know she doesn't have any character or integrity. These words put everybody on alert that the judge is violating their obligation to treat both parents equally and to act in the best interest of the child. And if the judge is half awake, she'll recognize you're planning to appeal the judge's final order, which most judges are afraid of. Whatever custody arrangement is made on the first day, ask the judge to include these 6 legal clauses. Do not assume the judge has the foresight or the intelligence to add these clauses to a temporary order. First, neither parent should belittle or insult the other parent in the presence of the child, nor allow any other person to do so. This puts the mother on notice that she shouldn't alienate the children from you by insulting you. Second, the parent shall not move away more than 10 or 20 miles from their current home, such that it creates a visitation burden on the other parent. This also blocks her from alienating you. Third, each parent is entitled to the medical and educational records of the child. Each parent will sign any necessary documents for providers to ensure the other parent has access to this information. Fourth, both parents have the right to attend all of the child's sporting events, school events, parent-teacher conferences, and religious ceremonies. And make sure you attend these events. Fifth, if the child is hospitalized for any reason, both parents have the right to visit the child during the hospital stay. Sixth, both parents may telephone the child daily. Despite your efforts, you might still be made a non-custodial parent on this first day of court. If that happens, then we'll go to Plan B. The rest of the docuseries will focus on how to win the full trial in the long run. In the next episode, we'll discuss the overall trial timeline and what happens after this first day of court. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. If you like, subscribe, and share, it'll also help the YouTube algorithm get this message out to more fathers in our position. Also, if you find this information helpful and you want to support this channel so I can make more videos, please donate via my YouTube channel's About page. You can donate via PayPal or Venmo.